Good afternoon, everybody. Welcome to Business Bites. My name is Henry. I'm here from the Kent and Victor Chamber of Commerce. Just a quick one before we do kick off the session. If you do have any questions at all throughout, please do put these into the chat and they will all be addressed at the end. So I am delighted to be joined by Cherry Shin today from HGF, who will be delivering this presentation all about brand protection. So I'm now going to pass you over to Cherry. Feel free to take it away.
Amazing. Thank you so much, Henry. Hi, everyone. My name's Cherry Shin. I do have a few apologies to make. I've been having a few issues with my camera right now, so you probably can't see me. I'm so sorry about that. But thanks so much for your time today. I'm going to talk to you today very briefly about how you can add value to your business through brand protection. So in this session, I'm going to give a very high-level overview of what you as brand owners should look out for when protecting your brands. I'm going to have a particular focus on trademarks today. And I'm going to divide this talk into four sections. So first of all, I'm going to talk about budget allocation. So, how much you should expect to invest at what stages when looking to formally protect your brands as trademarks. The second part is due diligence. So what steps you should take prior to launching your brand. Third is enforcement. So how you can stop other third parties from using similar trademarks to yours in similar business fields so as to avoid consumer confusion. And lastly, I'm going to give you a very brief introduction into other IP rights, such as designs, copyrights, and patents, which could be of interest to you as well. I also have to make another apology. I am suffering from a cold, so if I do cough or anything, I'm really sorry. So before I go on, I thought it'd be quite useful to give you a very brief background into myself and HGF, which is the firm that I work for. So I'm a chartered or qualified trademark attorney. I've been in this profession for around 8 years, and I've got 4 years of post-qualification experience. This slide is basically an overview of my firm in numbers, I guess. So we initially started off in 1995. We were originally a very northern firm, beginning in Leeds. Now we're across all the nation just because of the growing demand of IP. We also have offices in Europe. I think this slide is slightly outdated. We have around 25 offices and we have around 500 people within the office, all of the offices. So we're an all IP firm, so we specialize in trademarks, patents, and copyright, but we also have solicitors as well who help with high court litigation cases as well. So ultimately, I guess we're trying to brand ourselves as a European firm that delivers solutions for clients at every stage of innovation. So, for example, from inception to commercialization or from defense to enforcement. So I guess the next slide is just loads of pictures of people in our trademarks team. The bigger pictures are of partners within the team. And then you can see a very small photo of myself on the left-hand side. So the next slide is going to be about what a trademark is. And I apologize if this is very basic and you already know this, but I thought it'd be quite good to kind of give a breakdown before I go on. So the legal definition of a trademark is really that it's a sign which is capable of being presented in a clear and precise manner, and it's capable of distinguishing one undertaking from another. So in other words, in more simple terms, it's a brand signifier. So on the side here you can see quite a few logos, which are trademarks of really well-known brands. So for example, the Nike swoosh, McDonald's, Coca-Cola, YouTube, etc. But other than that legal kind of definition, what a trademark really is the face of your company. It's what consumers will see first, and it's able to communicate certain information to your consumers. So for example, if you had someone buy a product from you or a service from you, used your service, and they enjoyed a certain quality of it. Next time when they look at your trademark, they're able to make that connection with that quality. So it helps kind of communicate this information and also helps them make repeat purchases. It's also something that we call an intangible asset. So basically, in other words, it's property that you can't physically grasp, I guess. So you can, license it out for a profit, or you can sell it on later down the line. And also, as it's an asset, you can also secure certain investments through that as well. And finally, we tend to call it a negative monopoly right. So by that, I mean that it doesn't give you the right to necessarily use your trademark or brand name, but it does give you the monopoly right to stop others from using similar or identical names in similar or identical fields. So commonly, I guess, we think of trademarks as logos and words, but they can also take a shape and form in different sizes and different forms. So perhaps it might be a bit easier to think of examples than the definition. So this one is the shape of a chocolate bar. I'm not sure if you've been able to kind of recognize it, but it's a Kit Kat bar. This can also be a trademark. This is the layout of a particular store with electronic goods. I'm not sure if you've been able to identify it, but it's the Apple store. This color, purple, commonly associated with some chocolate, so Cadbury's chocolate, etc. So these are all kind of other forms of trademarks as well. So the last one is Netflix. So it doesn't necessarily have to just be a word or a picture or a logo. It can be other things as well. So as long as a sign, it's a sign, so it can convey a message. It's represented in a clear and precise manner, and it's capable of distinguishing the goods and services from one entity to another. It can be considered as a trademark. So another bizarre example could be a smell. Technically, they can be trademarks, but whether they can be represented in a clear and precise manner, that's quite a difficult kind of obstacle that you probably have to overcome. So going on to the first part of this presentation, I'm going to talk about budget allocation. So you're likely to incur costs at different stages of a trademark cycle. And by trademark cycle, I mean before you file, once you file, once it gets examined, once it gets published, once it gets registered, and then 10 years later when you're looking to renew, or when you're looking to enforce your brand or even defend it from other actions. So it's important that you're aware of where these costs will accumulate so that you can budget accordingly and not be surprised later down the line. So I tend to tell my clients that your costs are probably going to be heavy at the beginning when you begin to file. So that's because you might be involved in conducting some preliminary searches. So this is basically when you engage with trademark attorneys or specialists to have a look at what's already registered and let them advise you on whether they think that your new trademark application filing is going to be problematic, whether it's going to come into any issues with third parties. So it's not a mandatory step, but it's a preliminary step that helps you to mitigate risks later down the line. I'm going to talk a bit more about this later on, so I appreciate if that wasn't very clear, but yeah, so you might incur costs there. You could also incur costs at filing, so there's official UK IPO fees that you'll have to pay. If you're working with trademark attorneys, they're going to also charge you for their filing fee. Once it gets examined, if there's objections that are raised by the examiner, there'll be costs for your trademark attorney to report that to you, and then also to file a response to the objections. That's going to be an additional cost. Once it gets accepted for publication, your trademark attorneys might also charge you for that. And then if there are any oppositions that are filed against your application, that's where it could also get very cost heavy as well when you're trying to settle matters with third parties who might think your brand is too similar to theirs. But if that's all kind of, if you don't have issues and your trademark is accepted and registered, then you don't really have fees to pay after that. 10 years later down the line, when you want to renew, that might be an extra fee, but it's not that much. So there are costs involved throughout each stage of a trademark's life cycle, but thankfully for maybe small to medium sized enterprises, the UK IPO does have some funding options available. So if you just Google, SME financial support scheme or IP audit or something called IP advance, you'll be able to find kind of what funding options there are available to certain businesses. So for example, the IP advance one is targeted at SMEs. You need to meet certain requirements. For example, you have to have less than 250 employees and an annual turnover of less than 50 million, I believe. But these schemes are quite useful and they're designed to help companies identify a filing strategy as well as understand what risks there might be out there. So it's basically helpful for due diligence before you launch, I guess. So my next slide is about due diligence. So separate to costs, there are other factors that you should probably consider before launching. So I guess the first one is consider whether your brand is actually eligible for trademark protection. So as I mentioned, once you file a trademark, it's going to be examined by the UK IP office, and that's to ensure that it fits the definition of a trademark as we discussed earlier. So whether it's clear and precise and it's a sign that's capable of distinguishing a set of undertakings from others. So this is also put in place as a matter of public interest, so as to stop unfair monopolies being granted. So certain objections which could arise could be, for example, is it distinctive? So that's to do with whether it's like very basic words like the best or great or those type of words, or whether it's very short trademarks with like one letter or one number or one symbol. So they're going to examine it on whether it's distinctive. They're also going to examine it on whether it's descriptive. So does it describe the quality associated with the goods and services that you want to use your trademark on? Is it descriptive of the time and place that it was produced? So it's going to examine it for all of these type of qualities. And then another potential objection that could arise is your trademark misleading or offensive? So for example, does it offend a certain religious belief, or is it something that might be considered as offensive to certain members of the public? So these objections can be overcome if the owner has acquired distinctiveness through use, for example, training the public to recognize it as a trademark. So for example, I know that the mark Ultimate Fighting Championship was objected to because it was non-distinctive and potentially descriptive, but it was able to show that it had acquired distinctiveness through extensive use. So then it was accepted as a trademark. So at this, I guess it's a good idea to engage a trademark specialist during the brand creation and selection process stage. This is just to minimize risks of you perhaps having to rebrand or come into some objections that you might not be able to overcome when you do file your trademark. The second thing that I would recommend is conducting trademark searches. So these aren't absolutely mandatory, but these are a step to kind of make sure that you know what is already out there so that you don't come into issues with third parties when you do file or when you do use your mark. This can be done by engaging trademark attorneys or specialists as well. What they'll do is they'll look on the register and identify if there are similar marks already filed by third parties. And it helps us to understand the risks associated with proceeding to file or use your trademark. And I should mention that trademarks are territorial. So if you were interested in trading in the UK, but also in the US and EU later down the line, it might be useful to conduct your trademark searches before you launch in the UK, for example, just because you don't want to be using your mark in the UK and then maybe 3 years later down the line you want to use in the US or EU and then figure out that actually there was another party that had an identical or similar, brand name that you could have maybe figured out when you did conduct the trademark search 3 years ago. So that's something that you should probably look out for. But yeah, as I mentioned, searches aren't compulsory, but without them, you won't necessarily be aware of the risks associated with proceeding. And then the third thing is if you do ever conduct or engage with a third party to design your logo or your trademark, it's best that you have some form of written agreement which clearly states that any IP rights, for example, the copyright that arises from the creation of your logo, make sure that it's all assigned to you and your business. If you don't, there is a risk that the third parties could potentially use your marks in a way that maybe you don't want them to, or maybe they might license the mark out to other third parties that you're not aware of. So this is something that maybe you should have in place just to make sure that you are the owner of the actual trademark. And then I guess the last thing is when you file a trademark, you do have to specify the goods and services that you want to use your trademark on. You might have key goods and services that you're thinking of at the time of launching, but it's best to think maybe 2-3 years later down the line, are you going to use it on other potential goods and services? If so, it's best to secure that protection from the get-go rather than later, because you might have to file a new trademark application and that's going to incur extra costs. But you have to be careful, like if you're thinking of using your trademark on a particular list of goods and services, maybe 5 or 6 years later down the line, if you don't use your trademark for those goods and services, it could be challenged or cancelled. So just be aware this is only relevant for things that you want to use it on in the next 1 to 4 years from launching. So the next part I want to talk about is enforcement. And this basically means like what you can do to best protect your brand and stop others from using similar marks so as to avoid confusion on the marketplace. So first of all, it's best that you consider which aspects of your brand you want to protect and prioritize them based on importance, budget, and plans. So if we have a look at this have a break, have a Kit Kat picture here on the right-hand side, there's quite a few trademarks that you could protect. For example, the phrase have a break, have a Kit Kat is one. Kit Kat on its own is a potential trademark. I guess the picture of the broken Kit Kat is also a potential trademark. So if look at your budget, look at what you want to protect. Often I tell my clients to have to focus on a house brand. So I guess in this case, it would be Kit Kat. But yeah, so have a think about what you want to prioritize when you have certain trademarks that you can protect. Also, I would recommend that you use the TM symbol with any brand name that you use. So whether it's a slogan, whether it's a logo, whether it's a certain word, just make sure you put that TM symbol there. That's going to help kind of third parties identify that you are taking your trademark protection seriously and it can act as a deterrent or a keep off the grass sign. And if your trademark is registered, use the R in the circle symbol as well. I just want to clarify that if your trademark isn't registered and you use that R in the circle symbol, it could be considered as a criminal offence. So just be aware of how to use those symbols. And then the next one is I would recommend you create some brand guidelines to ensure that your brand logo is used correctly and consistently. If it's used inconsistently, a third party could end up challenging it for non-use, and your trademark could fall away. Also, if it's used inconsistently, there's a risk that your trademark could become generic. Some examples I can think of is the trademark Tupperware or Hoover. They used to be trademarks, but I guess they were kind of used by the general public in an inconsistent way that they've kind of become generic terms. So just make sure that you have a certain set of guidelines for your employees or for yourself to adhere to when using your trademarks. And then I would really recommend that you make a habit of gathering and storing evidence of use of your trademark from the start. So this can be putting your trademark on invoices, having annual sales figures to hand, keeping a record of how much you are spending on marketing and advertising, keep some screenshots of your website, photos of your products, and make sure that they're all dated or it's pretty clear from what date that they were gathered. This is useful in potential kind of actions that might be filed against your trademark or actions that you might file against other trademarks. So you can prove use, prove a reputation or goodwill. And then lastly, I guess, having a watching service in place. This is relatively cheap. It's done by trademark attorneys, and basically you ask them to keep a lookout for newly filed trademarks, and the trademark attorneys will kind of notify you as and when appropriate and advise you on whether they think that you should file a challenge or not. And then I put designs at the end. So this is a relatively cheap way to protect the look and feel of products and packaging. This is useful against lookalike or copycat products. So the last part of this talk is on other IP rights that you might be interested in protecting. So as you can see from this slide, there's things called trade secrets, patents, registered designs, and copyright. I've used the example of a Nescafe coffee jar here. So for example, I'll start with the registered design. So as I mentioned, designs that protect the look and feel of a product. In this case, the coffee packaging shape can be protected as a design. Similar to trademarks, it gives you a monopoly right to stop others from using the same design or a design that produces the same overall impression of the informed user. Again, they're relatively cheap and they're not substantively examined, meaning that you can also secure protection within 1 to 2 weeks of filing. So they're a very good potential alternative to trademarks. But there are certain requirements. For example, they're only valid for a maximum period of 25 years. There's a grace period in which you need to file them once you publicly disclose a design. So there's just a few requirements that you need to meet before filing. The next is patents. So that patents protect the technology behind new and novel inventions. For example, how an iPhone unlocks with Face ID. In this example, the freeze drying process, which is a method of making the dried coffee. So again, they have some disclosure requirements, so just be careful on that. Copyright, they're unregistered rights which protect works that are original. And in this case, I guess you can have copyright in the label itself or some of the wording on the label. And then trade secrets, This is a piece of confidential information that's not commonly known or accessible. This information can be licensed or sold for a profit as well. So in this example, the bean selection process might be something that can be protected under trade secrets. So to kind of wrap up my talk, basically trademarks do add value to your business. It's a tool which can help you monopolize certain signs and stop others from using similar signs in the same field. They can be sold or licensed for a profit. They can communicate certain ideas to your consumers. Again, trademarks can take many forms. It doesn't just have to be words or logos. It can be sounds or animations. And there are lots of steps that you probably need to take before you decide to launch your brand. I've listed them there. And then again, maybe think of other forms of IP which you might be interested in, which might be a cheaper alternative or a more appropriate alternative when it comes to protecting your products or, yeah, your business. So thanks so much for listening. I apologize again that my camera wasn't working, but if you have any questions, feel free to let me know.
Perfect. Thank you very much, Cherry, for that really informative presentation. Like Cherry said, if you have any questions at all, now is your time to ask. We have a couple of minutes still within the event, so either put your questions in the chat or feel free to unmute and ask away. So, did anyone have any questions at all? I don't know if you can see the chat, Cherry, but Rosie
Yeah,
and both thanked you for the
thank
presentation.
you.
Any questions at all?
If you
No.
ever think of other questions, I mean, feel free to email me. I don't know if I'm allowed to circulate my email on the chat, Henry.
Yeah, yeah, feel free to. Absolutely fine. Not a problem at all. If not, I can
Yeah.
share that with everyone afterwards. There we go. Cherry has put her email in the chat for you also. If you did have any questions that she wanted to ask a bit further down the line, then like Cherry said, please do. So if we don't have any questions, then that brings us very nicely to the end of our session. So, first of all, Cherry, again, I just want to say a massive thank you for that presentation today. And I also wanted to thank all of you who came along to time out of your day to come and listen. So, like I said earlier, I've been Henry from the Kent and Victor Chamber of Commerce, and I hope you all have a great rest of your day. Thank you very much. Goodbye.
Thanks, everyone. Thanks.